recording this session so that anyone who has a sick kid can watch this later. All right. Can everyone see my screen? Hopefully everyone can see. Welcome as people join. I'll be letting folks in. In the chat, can you guys start putting your kids' ages? I think that would be really fun to know what age we're starting to think about with our family planning. It took me a while. I have a 4-year-old and a 2-year-old. So feel free to start putting in the chat your kids' ages. I know we are letting folks in a little early. Appreciate you guys all joining this Friday. It's something you probably don't necessarily think of as a fun activity, but we're going to try and make it as fun as possible. So, all right. And I'm also going to be putting people on mute, please, as well, so we can ensure that we can all hear the presentation for today. Welcome, welcome, everyone. As you join, please put your kids' ages in the chat. We, as Sprinkles parents, are always trying to help those with kids under 5 years old, as I have a 4 and a 2-year-old, so I'm not sure how to help after 5. But so happy you guys are all here on this Friday. Finally, no rain in the Bay Area, which is nice. Welcome. All right, it's 2:01. We are gonna start kicking off in 1 more minute, I think. Is that okay, Matt?
That sounds great.
All right, awesome. All right, we'll give everyone 1 more minute. Just time to sign on, time to put your kids in front of the TV or entertain them if they're home, or hopefully if they're not home, if you have to wrap things up. We are going to learn about one of the most interesting topics I'd say I've never thought about before, parenthood, which is family estate planning. All right. All right. We are gonna get started. All right. So welcome, everyone. My name is Brooke Shapiro. I'm the founder of Sprinkles Parents. If we haven't met before, hi. I have a 4-year-old Jace and a 2-year-old Raina. And I am so excited to be talking about family estate planning today with you guys today. If you're not familiar with Sprinkles Parents, we provide education, activities, and resources to parents like you here in the Bay Area to help us thrive. We all made it through the pandemic. I think we can say we're on the other side, but parenthood is really hard. They forgot to give us a handbook at the hospital or if we adopted a child. And we don't have this village that they promised us it takes to raise a child. So through Sprinkles Parents, I really try to provide us resources and connections and amazing partners like Matt, who's going to speak to us about family estate planning today, so that we know where to go and how to set our kids up for success for a better world altogether. So with that, I am going to actually kick it over to Matt from Santos Walding to talk about family estate planning. So thank you, Matt, for joining us today.
Great. Thank you, Brooke, for inviting me, and thank you, everyone, for making time on a Friday to talk about a rather unpleasant topic. I'm sure there's a lot of things you'd rather be doing. I'm sure this is going to be fascinating for any of the kids who are watching, so we'll try to make this as painless as possible. And my name is Matt Walding. I'm an estate planning attorney located in Oakland. My business partner and I have a little 2-person shop here. And next slide. I do need to start with this. I'm sure if you've ever been to anything like this, you've seen this before. I do need to say up front, to comply with my ethical responsibilities, that what I'm doing today is sharing information. We're going to talk about some legal topics, but we are not giving legal advice today. And nothing that is said or shown on the screen today constitutes legal advice. There's no attorney-client relationship that's formed as a result of this. And I do strongly encourage everyone to consult your own attorney, financial advisor, and tax advisor based on your particular facts and circumstances. So I need to lead off with that. We'll, at the very end of this, we'll have some information about how you can reach out for questions if you have them, and we'll talk more about that. but I'm not your lawyer.
Unless you want him to be, right?
Well, yeah. Well, you have to talk to me on the side about that if you want that. But I'm glad you're here. I'm not here to try to sell myself to you. I'm here to try to share some information and hopefully help you think about how you might take some next steps to put your affairs in order. All right, great. Next slide, please. Just a quick overview. Today, we're going to go over, I'm going to do a brief introduction about what estate planning is. We're going to talk about some of the most common estate plan structures and the documents for those structures. We're going to talk about what I think is the most important topic in estate planning, which is guardianship for minor children. You know, I'm guessing from the ages of the kids in the chat and from the types of activities that Sprinkles offers, that most of the people in the room are probably on the younger side of the people in the world thinking about estate planning. So I want to congratulate you for coming today. You know, a lot of times I don't see clients until they're in their 60s and their kids are, you know, off at college and they have grandkids to talk about. So I love it when young families are thinking about this because you can do a lot at the beginning of a family's life cycle to smooth things out in the future. So congratulations. And then we'll talk about questions at the end. All right, next slide. What is an estate? So this is a term that gets used in a lot of different contexts and it means a lot of different things. My mother-in-law is a yard sale fanatic. And so when she hears the word estate, she thinks estate sale. That's the kind where we're going to get to like go into the house and look around at all the stuff. So that is one type of an estate. Typically, when we talk about estates from a legal perspective, we're talking mostly, just when we say that word alone, mostly about your stuff. So every person, if they were to pass away, they have an estate, and that estate constitutes the assets that they own at their death. But what is an estate plan? When we talk about an estate plan, it's much broader than that concept. We're not just talking about your stuff. We're actually talking about a comprehensive plan that will dictate what happens to your stuff, but also how the people in your life are impacted, who would be responsible for helping wind up your affairs, what you would want to happen to your property, how you protect your children, how you protect your family, how you do charitable giving, all of those sorts of things tied together into an estate plan. And so it's a much broader concept, and that's what we're going to be talking about today. Next slide, please. All right, true or false? Let's everyone ask themselves this question. You don't have to answer out loud. Just ask yourself, true or false? I don't currently have an estate plan. Let's give you a moment. True or false? Next slide, please. False. It was a trick question. Everyone has an estate plan. Whether you like it or not, you have an estate plan. Next slide, please. There are two types of estate plans. One is the type that is designed by you, where you and your family make the decisions about what happens to your stuff, how do you protect your children, all of those sorts of decisions. The second type is designed by state law. So this is a presentation for California residents. So this is the California Probate Code. And if you haven't done any planning, then this is your estate plan right now. So you can pick up a copy of that in your library and read about what's going to happen in the event of death or incapacity. So hopefully after today, you're going to want to design your own plan and move into category number 1. Next slide, please. All right, we're going to try to, this is a lot of information on the slide, so I'm going to try to go quickly through this because I don't want us to get overwhelmed. I just want to sort of at a high level for you to think about each of these columns represents a type of estate plan. So on the far left, we have the estate plan for the person who has not yet done anything. And so this is your California Probate Code plan. And what does that look like? It means you currently don't have a will or a trust. You don't have any agency documents. Those are things typically called a power of attorney document or a conservatorship nomination or a guardianship nomination. Those are the forms where you name someone else to act as your agent for some purpose. You don't have any healthcare documents giving your instructions around healthcare, and you haven't made beneficiary designations on retirement plans, life insurance policies, things like that. So what happens in that kind of an estate plan? Your default outcomes are determined under state law. And so the probate code is typically going to look to next of kin for most things. And there are certain definitions about what that means in different contexts, and there are exceptions. But in general, the probate code will govern. If you're married, then having this type of an estate plan might not be super consequential at the death of the first spouse, because the probate code does favor the surviving spouse in most instances for most roles and for most property entitlements. So it's It's something that may not be, as significant for someone who's married, but it's still something where you would want to understand what would happen. Now, the most significant thing about this type of an estate plan is that there is a probate court proceeding that's required after your death. So if you die without a will or without a trust, your heirs need to go to probate court. So this is a civil court. It's a division of the California court system. And when someone passes away, the heirs need to file a petition in that court where you have to submit an inventory of all your assets, talk about all of the beneficiaries, and a judge has to approve the distribution of your property. A judge approves guardianship for minor children. There's an involved proceeding that involves a long time and legal fees. So currently in Alameda County, I think we're looking at, depending on how simple the case is, anywhere from 6 to around 24 months to process a probate. And there are statutory attorney's fees, statutory executor fees, so it can get very expensive. It's the most simple type of estate plan for you. So you don't have to do anything to have this type of estate plan. So it's simple for you, but it is the most, it is a very complex estate plan for your family because of that probate court proceeding. So then if we move over here to the next type, this is a will-based plan. So we've all seen movies where the family gathers for the reading of the will. I think before I became an attorney and was familiar with this, that's kind of what I thought an estate plan was. I thought if you had a will, you had an estate plan. That is one very common and very good type of estate plan. It's appropriate for a lot of circumstances. So if you have a will, you basically have a document that says who's going to take care of things if I can't, and who gets my stuff. So that's a last will and testament. The will also can name guardians for minor children, a very important thing. So when you have a will-based plan, you typically have additional documents that goes with the will, including that power of attorney document, guardianship nomination, a healthcare agency. So that's a document where you name an agent who can make decisions for you for healthcare and leave some preferences around that. And then you've made beneficiary designations on your retirement policies and life insurance policies. So that's a good situation. The outcomes are then determined by what you've said in the will. The problem with that is that you still have to have a probate proceeding after your death. So that even though you have a will, that will has to be taken to court and probated. So the court has to approve what the will says. Unless, I should say this caveat, unless your assets are less than $184,000, if that's the case, then you don't need a formal probate proceeding. And if you have questions about that, we can go over that later. I'm going to pause for a moment. Speaking of questions, going kind of fast here. If you have questions as I'm speaking, I'm trying to keep my eye on the chat, so feel free to pop those in there and I will try to answer them as we go. All right, moving over to column 3 now. This is what we're going to spend some time talking about today. You might have heard about this type of estate plan. It's the revocable living trust structure. It's sometimes called a living trust, sometimes called a revocable trust, sometimes called a revocable living trust. So in this situation, you have a will, but you also have a trust. And we're going to talk a little bit in a minute about what that looks like. You basically establish a trust during your lifetime. You fund the trust with your property. You have a will. You have those same agency documents, healthcare documents, and beneficiary designations. Now your outcome is determined by what the instructions that you leave in your trust, your will, and those other documents. The big difference here, no probate court proceeding is required. So to the extent that you've properly funded the trust during your lifetime, the property and the trust should not be required to go through a probate proceeding, which makes this a much more simple administration of your affairs after your death for your family. I see is a family trust just one type or form of revocable trust. So the term family trust can mean a lot of things. It is one of the ways that we sometimes name revocable living trusts. So we might call it, the Shapiro Family Trust. We might call it the Shapiro Family Living Trust. What makes the trust a revocable trust is that you can change it during your lifetime. And so we'll talk about that a little more in a minute. That's actually a good question to segue into the final column, which we're not going to be talking about today. This is an intro to estate planning, not an advanced estate planning seminar, but I do want to let you know there is a more advanced structure that involves the use of irrevocable trusts. So unlike a revocable living trust that you can change during your lifetime, irrevocable trusts, once you set them up, they typically cannot be changed. And these trusts are used typically for tax planning. So if you have a large estate, you might have some tax planning done with these trusts. They're also sometimes used when you have children with developmental disabilities or other special needs or obstacles. They might be used for Medicaid planning to help prevent spend down for Medicaid in older age. So there's some other reasons to use these, but we're not going to be getting into that today. All right, next slide, please. So in your will-based plan, there are a number of documents, but the four primary components of a will-based plan are your will, your agency documents, your healthcare documents, and your beneficiary designations. And so we've talked a little bit about this already. I'm not going to spend a lot of time, but the will says who will wind. Looks like I muted myself. Sorry. The will say, oh, did you want to say something, Brooke?
Yeah, I did. Sorry. I'm just trying to remind people to go on mute. Sorry. There was someone playing music in the background. I apologize. And accidentally muted you.
The music is more interesting than what I'm saying, so we might go back to that. So the will says who you would like to wind up your affairs. So that's we think of that as the executor or the personal representative. Those words all mean the same thing. So who's in charge of taking care of things. Instructions for who gets your stuff. Very importantly, a will is where you can name guardians for your minor children. If you were to die while they were still under 18, you can leave instructions about who you would want to care for them. And a will can be used to do some more advanced planning, which I'm not going to focus on today. Agency documents, the power of attorney document. This is a document where you name someone to manage your financial affairs and your property in the event that you're alive, but you're not able to manage things yourself for whatever reason. This can be currently effective. You often see that in older age. So, an elderly parent might currently give their child a power of attorney to take care of taxes and things like that. Or it can be springing. We see these more often for younger families. Springing means you name in this document who's going to take care of things, but it doesn't actually become legally effective until a doctor determines that you are no longer able to manage your affairs. Power of attorney documents can also be used to name guardians for children. And this is important because the will is only effective after you've died. So if something happens to you and the children need to be taken care of, you can have a power of attorney document that says who will do that. In California, we also have a standalone form for naming guardians, and that's a nice agency document. We'll talk a little bit more about that later. Healthcare documents. In California, it's called an advanced healthcare directive. It's a document where you name who would make medical decisions for you if you can't. You can name a backup. You can name two backups. It's an important thing. You would want some control over who would decide important things about your healthcare. And then this is the document where we have the morbid matters. So this is always the least fun conversation during a client intake. So these are things like your preferences around life support, organ donation, and disposition of remains. So all of the really the morbid stuff. You might not want to think about that, and that's okay. It's up to you. You don't have to put those preferences into your advanced healthcare directive. It's an option if you'd like to give your healthcare agent some more information in case they have to make those decisions. And then healthcare documents also include HIPAA authorizations. HIPAA is a law that prevents the disclosure of protected medical information unless there's been an authorization. So you typically will want to authorize your healthcare agent, at least, maybe even your other fiduciaries, the ability to get some of that information in case they need it to make those decisions. And then finally, the estate plan also includes a review of your beneficiary designation. So if you have a 401k or an IRA, a 403b, 453b, any kind of retirement plan, if you have life insurance, if you have bank accounts that name a survivor, if you have other types of jointly owned property, those things can be fine-tuned to integrate with your estate plan. But whatever it is, you want to make sure that you've thought about who would get the benefit of those accounts if something were to happen to you. All right, moving on. Next slide, please. We're going to talk a little bit about the revocable living trust, also called the living trust, also called the revocable trust, also called the family trust. They couldn't just call it one thing. Here we're going to call it a revocable living trust or an RLT. And to think about what this is, we're going to use the metaphor of the box. So if you imagine a box and you're holding a box and you put this stuff into it, there's only certain types of assets that are appropriate to go into the box. We'll talk about that a little bit. Primarily real property, personal property, which means anything you can touch. So keepsakes, jewelry, artwork, musical instruments, the the drawing that your kid made for you when they were, 3 years old that you frame and cherish forever. That's tangible property that can go into the trust. Bank accounts, so checking and savings accounts can go into the trust. Brokerage accounts, these are taxable securities accounts with like Charles Schwab or Fidelity or something like that. Closely held businesses, if you have an LLC or an S corporation, or if you're running a sole proprietorship of some kind, you can assign those businesses to the trust. So put them in the box. And then other assets, there's a broad category, which is too broad to go over everything today. So all of those assets are appropriate to put in the box. You put them in your box. Next slide, please. And you give the trustee, this is a person or an institution, usually a person, you give the trustee the authority to manage and control the assets in the box. So in a revocable living trust, during your lifetime, you are typically the trustee. If you're married, you and your spouse are typically co-trustees while you're both alive. If one of you passes first, the other is typically the surviving trustee. And the trustee has the ability to say what goes into the box, what comes out of the box, what do we do with the assets that are in the box. Next slide, please. The trust also has beneficiaries. So the beneficiaries are the people named in the trust who have the ability to have the economic benefits of all the property in the box. During your lifetime, this is you. You are the trustee and the beneficiary of your trust during your lifetime. If you're married, the beneficiaries are you and your spouse during your joint lifetimes. Next slide, please. You type some instructions on the front of the box, your trust instructions, and they're taped there so that everyone who sees the box can read them. And these include the names of future trustees. So after you or you and your spouse are no longer able or willing to serve as trustee, the instructions say, who do I hand the box to next? Who will become the next trustee? The instructions also include details for future beneficiaries. So who's going to get this stuff after I'm gone? And are there any additional instructions? There's some abilities, there's some structures we can use to protect beneficiaries. For example, you might want to protect your kids' inheritances from a future divorce. There's a way to do that in this living trust structure, and those instructions would be taped on the front of the box. If you have a child who has special needs, the instructions on the box could also say what happens to that child's inheritance. How do we protect that from disqualifying the beneficiary for government assistance, SSDI, Medi-Cal, things like that. There's lots of things you can put in these instructions. In addition to the trust, this type of estate plan also has a last will and testament. Here it's called a pour-over will. And what the last will and testament here says is that if I forgot to put something in the box during my lifetime, then after I die, the will says I leave that property to the box. I'm leaving it to the trust. So it pours over from your estate into the trust. And that's what the pour-over will says. Next slide. There are certain assets that are not appropriate to put in the box. And this is, there's some reasons, but basically retirement accounts have to be owned by the employee. They can't be owned by the trust. Life insurance, life insurance can be put in certain types of trusts, but for revocable living trusts, typically not. Annuities, which are similar to life insurance, a contract to give you a payment over a lifetime stream. These are beneficiary designation accounts. They can't be owned by the trust, but the trust can be named as a beneficiary. So part of your estate planning is to look at all of these contract assets and say, who do I want to name as the beneficiary? You might want to name the trust because you might want the funds to flow through to follow those instructions that you've taped on the front of the box. You might not want to. If you're married in particular, you might want to name your spouse as the primary beneficiary for a lot of these, but these are the types of conversations that you want to be having. So that's the metaphor of the box. Moving on, next slide. So in a revocable living trust-based estate plan, which was that third column, it's a little more advanced than a will-based plan. And it's a little more advanced because we have this trust document. So on the far left column, you have a trust agreement. So this is a document that establishes your trust. It names the current and future trustees who manage the property. It allows for property to be managed for your benefit if you're incapacitated but still alive. It offers some creditor protection opportunities for your beneficiaries, which we can talk about offline if you have questions about that. And the trust, importantly, allows property in the trust to not need to go through a probate proceeding after your death. Last will and testament, it does that pour over that we talked about. It also allows you to name guardians for minor children. And then the rest of the documents are the same as in the will-based plan that we've already discussed. Next slide. All right, we've talked about a couple of the most common estate plan structures for a young family. We're now going to talk about the most important topic. So if you have children under the age of 18, there is nothing more important than this. If all you want to do right now, if all of you have the capacity to do, is think about this one topic, you can kick the can down the road on the rest of this if you want to, but I strongly encourage you to consider getting some guardianship forms in place if you don't have them already. So, you have kids, and that's why we're here together. This is a parenting group, right? So the most important thing you can think of in your life is how to take care of your children. And if you can't be here, who do you trust to do that? That's a very important question. And there's no right answer to this. It's different for every family. It might be, it might be something that you know already. It might be something you need to think about. But from a legal perspective, there's a few things I want to make sure that you are aware of. So the types of guardianships we have temporary guardianship. So you can name someone who would take care of the kids for a short-term emergency. So, who would pick the kids up from school or daycare? Who would, watch them for a weekend if something were to happen, if you were in the hospital or something like that. And then the guardianship that we typically think of, which is a legal guardianship. It's a permanent guardianship for long-term incapacity or death. So this is where you're thinking, who would I trust to raise my children if I couldn't do it? And so there are two primary roles there. One is called guardianship of the person, and one is called guardianship of the estate. So they're separated out. Guardianship of the person is physical custody. So who decides what the kid is going to wear to school today? Who decides where they're going to go to church? Things like that. Where are they going to live? What are they going to eat? And then there's guardianship of the estate. Who's responsible for making sure that your assets are preserved in a way to benefit the children and to make sure that they have what they need throughout their childhood? The same person can serve in both capacities, but you're able to split those roles if you have people in your life who you trust for one but not the other. So that's a decision point. It's very important if you're married or if you're co-parenting with someone who you're not married to, that you discuss with the person how they feel about this, because it's in a perfect world, both parents will have a coordinated approach to guardianship. It doesn't always work. Each parent is entitled to have their own forms, of course, but it's probably easier on the child if the parents do coordinate. Documents that are used to nominate guardians. So there's the last will and testament. So this says who would take care of your kids if you were to die. There's a power of attorney document. This says who would take care of your kids if you were alive but unable to care for them. And then in California, we have a standalone guardianship nomination form, and this can work for both death and incapacity. And so this is a very brief form that can, if you're not ready to do all of those other documents, I encourage you to at least do this. It's a 2 or 3 page document that just says, who do you want to be guardian of the person? Who do you want to be guardian of the estate? And what does it mean to have these documents in place? So a court in California gives strong deference to a parent's guardianship nomination. So they do not give the same type of deference to a nomination from someone who's not either a biological or adoptive parent. But for parents, if you leave these documents, if you properly execute these documents and leave them in place, a court will defer to your choices unless there's a strong reason not to. So there's always an opportunity if there's a situation where there's abuse or neglect or something like that, there's always an opportunity for someone to override this. But in most cases, unless there's evidence of something like that going on, the court will honor your wishes as a parent. We have a question here. Are there additional requirements if guardian is out of the country, different citizenship? So there's no limitation on who you can name as guardian. There could be some jurisdictional issues with getting the guardianship formalized. You probably need to coordinate with a court in the other jurisdiction as well. But if the child was in California at the time, if you were a resident of California at the time of your death, the California court should have primary jurisdiction. Can you name 2 sets of people, like your own parents and then someone else? Yes. So you can have, so I've had clients who will say, there's a husband and wife, and they say, we want the wife's father and we want the husband's mother to be co-guardians. And that's perfectly fine. You can say, I want, spouse 1's parents to be first in line and spouse 2's parents to be second in line. And a cousin to be third in line. You can have consecutive, you can have co, you can do that however you would like. All right, so how do you get started dealing with these tricky questions? Here is a little chart that might be helpful. I'm happy to circulate this later if you would like it. So ask yourself the who's, the how's, and the what's. Who do I trust to take care of my family members? Who do I trust to make financial decisions? And who do I trust to make healthcare decisions? Those are three very important questions. If you have those questions answered, you actually have enough to get started. So who do you trust? How do you want to be taken care of in a medical emergency? How do you want your family members to be taken care of if you can't be there? And how important is it to you to make things as simple as possible for your family after you're gone? And then what do you want to happen to your stuff when you're gone? What values do you want to encourage in your family members when you're gone? And what is important to you to leave as part of your legacy? And by legacy, we mean a couple of things. Legacy means, financially, what are you providing for your family? Maybe there's charitable giving, that's part of your legacy. And then unfortunately, the experience of your family as a result of an early death is part of your legacy. So, I often deal with people who are going through a probate proceeding and there are conflicting emotions. They miss their loved one, but they're also very frustrated with how tangled the financial affairs are and how much work is involved in taking care of their affairs. That's part of the person's legacy, unfortunately. So by taking the steps today to put things in order the way you want them, it's actually a gift to your family. All right, another question. How do these documents get executed? For example, if the parents pass, do the kids end up in foster care until the court figures out who deferred to for court guardianship? It really depends on the situation, Irene, but typically it's a very quick process to get the guardianship forms acknowledged. There might be situations where there has to be a court proceeding to prove the guardianship, and given the many situations that might arise when someone passes, the physical custody of the kids is something that hopefully will be followed what's in the forms, but it might take a proceeding to get that to happen, depending on who took custody of the kids. All right, next slide, please. We have some time for a Q&A. And yes, so here's this. So this is another part where I am doing attorney advertising. Prior to this slide, everything that I've been doing has been just information to share. Now I'm actually doing a bit of advertising. You are under no obligation whatsoever to reach out to me, but I do want to let you know that you're welcome to if you have questions that came up for you during today's call. I'm not your attorney, but I'm happy to talk to you about a question you might have or what it might look like to be your attorney. You are welcome to use this Calendly link to schedule a 15-minute consultation. Sometimes they run a little longer than that. There's no problem with that. You just mention in the Calendly when you're booking it that it is through Sprinkles Parents, so that I can make sure not to charge you for that. So it's a free consultation if you want. You're also welcome to email me or call me if you have a question. And I have a pretty broad network of other estate planning attorneys. We can talk about what you're looking for. And if I'm not the right fit for you, I am happy to help you find another attorney who might be the right fit for you. All right, we have another question here. Every time I bring up drafting these documents, my husband, who is also an attorney, says that it isn't necessary since the custody part would always go through probate court anyway. What would you say to him? Well, the number one thing I would say to him is that although unlikely, it is possible for an event of simultaneous death. So there's the horrible scenario of it's date night and you get into a car accident. So what would happen then? So the probate court would have to weigh the varying competing interests of different grandparents, siblings, others who might feel like they are in a position to raise the children, and now you've caused family conflict. So much better for you to leave your wishes so that in that very unlikely event, your wishes would be followed.
I'm just putting in the chat, Matt, Calendly link for anyone who wants it.
Thank you.
Yes. Katie, my husband said the same thing. He's attorney and said they just go to probate. But then I found through, I don't know if Matt, you or someone, I've spoken with a lot of folks trying to learn more. It's like, what, 18 months or something in probate court, which is a really long time for them to wait.
Yeah,
to
guardianship
discuss.
hearings can be more on an emergency basis, given that the kid needs to be taken care of, but the outcome is what you can't predict necessarily without putting your wishes in writing.
Yeah, for sure. I'll share really quick, like my story of like why I wanted to look into this, just for anyone if it's helpful. It's like I was telling Matt before this, I was talking to my mother-in-law and she was babysitting one night. And she's like, well, worst case, something happens to you, I'll take your kids, bring them back to New Jersey, and then they'll go to this school and that. And I'm like, that's not what I wanted for my kids. Like, did you just kind of assume that's what I wanted? And my mother-in-law at that time said, is like, you need to, set up a will if you have something different than what, we're all assuming we're going to do if you guys, something happens. So I think it's really important to have clearly stated what you want somewhere, because your family may assume something different and want it to be them. Looks like there are more questions in the chat, Matt.
Yes, Vanessa says, where can we find guardianship forms? Are they available through a government website? The California courts do have a guardianship webpage that is typically used. I believe it's mostly for petitions to seek guardianship. For the nomination forms, I'm happy to share a form with Brooke that Brooke can send around if you would like. That is pretty simple. Let's see, if you don't have any unique set of assets or circumstances, can we download these forms online and sign documents in written by notary? So so there is a very simple statutory will in California. Let me actually put that link in the chat real quick. So in California, we have the ability to do statutory wills, which are very helpful if you don't want to incur legal expenses. There's the link to that. So a statutory will allow you to name an executor. It'll allow you to name beneficiaries for simple disposition. So if everything is going to your kids, for example, you can use this form. And it will allow you to name guardians for minor children. The will needs to be filled out completely with following the instructions in the will. And it needs to be signed in front of 2 adult witnesses, neither of whom is a beneficiary or executor under the will. So you could find a friend or a neighbor to witness your signatures. That's a perfectly good way to do sort of a backstop. That would control guardianship in the event of death. There's also a statutory power of attorney form. I don't have that link handy, but if you Google California statutory power of attorney, you should be able to find that. And that will allow you to do the same thing on the power of attorney front. Beyond, let's see, I think I missed a question. Let's see. Okay. Would you be able to go over the differences between the revocable and irrevocable trust? Sorry, no problem at all, Linda. So a revocable trust, in that metaphor of the box, is that trust that you set up and you put your stuff in during your lifetime. What makes it revocable is that those instructions that you tape on the front of the box, you can change them, you can rip it up, you can throw away the box, you can revoke or change that trust anytime you want during your lifetime. An irrevocable trust is a box with instructions that are not supposed to be changed. So once you fund that irrevocable trust and tape those instructions on the front of the box, it's supposed to stay the same. No changes to trustees, no changes to beneficiaries. There are situations where you can change those trusts, but that's really the distinguishing factor. The reasons you use them are different as well. A revocable living trust is a very, I don't want to say universal, because there are situations where it's not appropriate, but it's a very broadly applicable type of estate plan that can accommodate plans for a family. An irrevocable trust, you use them for very specific purposes, usually tax planning for to care for someone with special or special needs or disabilities, and then Medicaid and Medi-Cal spend down planning, and a few other, some charitable planning uses irrevocable trusts, but those are the primary reasons you use them. Okay. Kristen says, is there any benefit to the revocable trust over a will besides making it a little easier at death? So the revocable trust, in addition to avoiding probate after death, the revocable trust also allows for incapacity planning. So yeah, all of the assets are consolidated in the trust. And if you are alive but incapacitated, the trustee will change to whoever you've named to be the trustee. So what that means is that the successor trustee during your lifetime could take that box and manage the property for your benefit. That's an additional benefit. You can accomplish the same thing through a power of attorney document, but it's potentially a little more difficult to administer. But that's the other thing that comes to mind. Okay. Okay, I think Allison's question is similar here. Let's see. I mean, price, so we're talking about comparing a will-based plan to a trust-based plan. Price is also, it's relevant. I mean, part of looking at what you want to do in your estate planning is how much do you want to pay, and trust plans are typically more expensive. So that's a consideration, certainly. You can accomplish the same things with a will and an effective power of attorney document. It might be a little more difficult for your family to administer, but that's a choice for you to make. Okay, we have says, I always wondered this, but when you die, is everyone just on a search for your will or your trustee? Or is what people typically do is tell a few people where it is? This is a great question. The hunt for the will, like, where is the will? So it does happen that people's documents are not saved in a safe place. When you have a will, you need to keep the original somewhere safe, because when you die, that original will has to be taken to the county where you died and put into the county records. So that's, whether you have a trust-based plan with a will or just a will-based plan, you need to keep that original. It's a good idea to have digital copies in this day and age, and to let the important people know where the will is, what's in the digital copies. For my clients, I keep a copy of a digital copy of their estate plans. When you finish an estate plan, you get a big binder that looks like that you get to keep. And then there's a digital copy that's saved on our client portal. And I think most estate planning attorneys today do have digital copies as well. But keeping the people you've named as trustee or executor, letting them know at least that there is a will or a trust, and maybe the attorney's name, is going to be helpful for them to keep track of those records. But I love that question. It makes me think of movies.
Awesome. I think that's all the questions we have. And thank you everyone for joining us. And thank you, Matt, for teaching us. If anyone has questions, please reach out to Matt. I'll put his contact in the follow-up email, and a recording of this in the follow-up email as well. And if anyone is looking for more parenting guidance, advice, connections, for Sprinkles parents, next week we have a mom-turnships where moms come together and talk about what's happening with their kids. And after that, the invisible load of motherhood. And we're going to have a baby meetup soon, just been rainy, so we're going to bring that back. But again, please reach out to Matt or myself if you have any questions, and we can help you guys set you and your family up for future success. So thank you, Matt, again, and thank you everyone for joining us today. Enjoy your Friday.
Thanks,
have
everyone.
Have a good one, everyone.
Yeah.
Bye.
Bye-bye.